Call Kevin Haig.
Thank you, Mr Chair, and can I begin by joining others in acknowledging the particular contribution that's been made by the Minister to this Parliament and to previous Parliaments. It's a worthwhile contribution always. I hadn't been intending to take a call on this bill, sir, but just having a good look at Part 2 suggests a contribution that I can make. I'm a person that does have some significant experience of the criminal law, although I've always chosen to defend myself rather than to avail myself of legal aid, and I think I'm pretty proud of my record of acquittals, I have to say, and on criminal charges, probably exceeding that of most legal aid lawyers. But what I wanted to draw attention to was picking up on this theme that several speakers have mentioned this evening of that universal right to access to justice, because that seems to me to be pretty fundamental. And what's drawn my attention is Clause 8, because Clause 8, 1c sub 2, provides limitations on that right to access justice. And I guess we need to be pretty confident, if we're going to impose some limitations there, that those are reasonably justified limitations. The Minister has talked in this debate about his intention in this overall review or reform program in the justice arena of putting in place incentives. And I guess what I'm concerned about is that Clause 8, Subclause 2, lists a series of grounds that the Commissioner is required to take into account when applying 8 sub 1 C2. So a list of grounds, and bearing in mind the incentives that the Minister is putting in place in the bill, it effectively invites the Commissioner to use those grounds to deny legal aid. What I'm concerned about is that some of those grounds seem to me to be not relevant to actually determining what the interests of justice might be. I'm not going to address all of them, but if I could perhaps just draw attention to 8.2 sub 1, so whether the applicant has any previous convictions. So the Commissioner is invited to take that into account in determining whether or not the interests of justice are served by granting legal aid in relation to some new offence. It seems to me, sir, that previous convictions cannot, in fact, be relevant to whether the interests of justice are served by a person who is accused having access to legal aid, access to justice in a given case. So, and it seems to me that probably this has arisen because Clause 8, 1, C2 relates to that situation where an offence is punishable by less than 6 months imprisonment, and probably that's considered to be a relatively minor offence where actually the consequences aren't so severe in the case of a conviction. But in fact, sir, the consequences of a conviction that carries less than 6 months may in fact still be extremely severe for the person who is facing that charge. And so I'd invite the Minister to perhaps comment on how that might possibly be relevant, how those previous convictions might possibly be relevant to determining what the interests of justice are in the case of a person charged with some new offence. And that's really all I had to say about the bill on this part, sir.